The jury in the George Zimmerman murder trial has the case now. Let's go sort of inside what they are considering, what the ramifications of their decisions will be. Let's bring in Ryan Smith, our HLN anchor, who is also an attorney. Ryan, so they don't actually know as they consider whether this is second-degree murder, manslaughter, or he is not guilty. They don't know the sentences that accompany their decisions.
That's right. They have no idea about the sentences, and we like to keep it that way in the law because we don't want people to be influenced by that and say, well, I would love to give him this, but I don't want to see him go to jail for that long. Or I'm not going to give this because it just doesn't seem right. You want them to base it on the facts and the law. So they have no idea what the sentences are. And what's interesting about this is if second-degree murder carries 25 to life, mandatory 25 with a firearm, and manslaughter carries around 10 to 30. So they could have some overlap there. And then the judge can always downward depart from those sentences if she sees a way to do that. So we'll have to wait and see. But they have no idea what the penalties are, just the law and the evidence.
And so they've had to consider this idea of if a gun was used. I mean, obviously, we know that a gun was used. But explain that. Part of this has to do with mandatory minimum gun sentences there in Florida.
That's right. They're part of the life gun laws here. And the idea, a lot of this comes from a lot of the gun crime that has increased really all over the country. But in Florida, what they tried to do was address that by saying if you have certain crimes that are committed with guns, then we want to add on certain penalties, and in certain cases, add on mandatory penalties. So that kind of raises the ante so that we're not just hopefully, I think the idea is deterrent a little bit. Whether that works or not is debatable, but that's what sets in some of these mandatory, for example, for second degree with a firearm, and then also that higher sentence for manslaughter if a gun is used.
That's right. It was a controversial law, I believe, when it was enacted by Governor Jeb Bush. Use a gun and you are done. Supposed to be a deterrent, as you mentioned there. Ryan Smith, HLN anchor working this trial. Thank you for that. And, of course, one of the things I think that people are wondering now that the jury has the trial, how long are they going to deliberate? Is it going to be hours? Is it going to be days? Could it be going on more than a week? So let's bring in now Richard Gabriel. He is a jury consultant. You know, when you take a look at these high-profile cases, you can certainly understand why it takes so long. You know, it took Jodi Arias's jury, Richard, about 15 hours to convict her in the first-degree murder of her ex-boyfriend, Travis Alexander. Casey Anthony's trial took jurors 10 hours, 40 minutes to acquit. Conrad Murray, 9 hours to convict him in the involuntary manslaughter of Michael Jackson. And Scott Peterson, jurors took a whopping 7 days to convict him of 2 murders. Jurors in the O.J. Simpson murder trial took under 4 hours to acquit him in 1995. Now, one thing of note, all of these juries had 12 members. There are just 6 in the George Zimmerman trial. Is this going to make a difference, Richard?
Well, it can make a difference, but it really depends on the individual personalities of the jurors, how much evidence they go through, how comprehensive they are, and also if there are divisions that emerge. The thing that I also want to make sure everybody understands, we talk about the process, and I've been involved in a lot of high-profile cases where there's been unpopular verdicts. We really need to respect the jury's verdict in this case. We can disagree with whatever verdict they give, but we need to respect it because they have a tremendous amount of pressure being put on them to do the right thing in this case. The interesting part about this is that the prosecution and the defense have both staked out very clear pictures of what they think happened. And the truth is that jurors, it's more like a jigsaw puzzle to them in which they are taking pieces from both the prosecution case and the defense case and creating their own composite picture. So it may not be this depraved mind that the prosecution is saying. It may not be this Trayvon armed with a block of concrete that the defense says, but they may try and put this composite picture together. That may take some real time as they try and fit all these tiny jigsaw pieces together to arrive at what they think happened here.
And how do they do this? Are they going through these pages and pages of instructions that we heard Judge Nelson reading out? Do they kind of go through that as a checklist, generally?
Well, they typically do it a couple different ways. One is they can sometimes spend even days saying, let's divide up the evidence. and go, let's take a look at the forensic evidence. Let's take a look at the 911 calls. Let's take a look at the eyewitness evidence. And they parse those out, and they go through those, and they debate each of those particular pieces of evidence separately. They can sit there and say, let's go through the jury instructions and make sure we know legally what we're supposed to be doing and how to follow those guidelines. Sometimes, and again, this tends to happen when you have quicker verdicts, is they go, let's go to the first question and let's say where everybody's at and see if we're in uniformity about that, and that can determine it. So there's a number of different paths this jury can take, but more importantly, I think they really do want to take some time because they realize that this is an important decision.
Certainly. Richard Gabriel, thank you so much for your insight on that. And coming up after the break, you know, one of the things that certainly a jury consultant like Richard can tell you is it really matters what a jury hears last before they deliberated. Well, today it was a very powerful, emotional rebuttal closing argument by the prosecution. We'll talk about that straight ahead.